Hello, my name is Neil Nolen. I'm an American human rights attorney, and I'm very pleased to participate in the Tomorrow's Lawyer program. The Tomorrow's Lawyer program asked me to present on the topic communication with the legal community. So I would like to offer some of the best practices examples I have from the international community and from the United States on 3 specific topics. The first being the advantage of joining not one but many bar associations. Secondly, maintaining your legal accreditation and advancing your legal skills in particular areas of legal practice. And lastly, how legal skills training is matched with obligations for pro bono service. So what are the advantages of joining a bar association, and why on earth would anybody join more than one bar association? Well, let me give you a couple examples. In the U.S., there's no legal requirement to join any bar association at all, but most attorneys find it very useful to join not only the American Bar Association as the largest, most prestigious, national level, and best organized bar association in the country, but they also join multiple bar associations at many levels. It's possible to join your state bar association, your county bar association, even your city bar associations, depending on the area of expertise and your area of practice that you want to develop a specialization in. Let me give you a specific example. My best friend growing up, his name was Bernie. So when he became an attorney, we started calling him Bernie the Attorney. Bernie the Attorney practiced with his father's small firm in suburban Philadelphia, and he served as a dutiful member of the Montgomery County Bar Association. Trained by the Montgomery County Bar Association, he developed his own expertise in estate planning and inheritance. Over the course of 25 years, he developed so much expertise in this field that he himself became a trainer for the Bar Association in the field. And he took advanced degrees sponsored by the Bar Association. So he has legal doctorates in escrow law and inheritance law, sponsored by his Bar Association so that he could serve as a trainer to young attorneys. Now, his association with his county bar association not only generates more business for his firm, but it also raises his personal credibility with local courts as a subject matter expert, somebody with strong backing who, as an adversary, you don't want to tangle with in court because he's so well respected through his bar association. So he serves his clients very well, and he raises the level of professionalism and expertise within his county legal community. And yes, he gets very rich doing it. Okay, just a quick word about bar association membership and fees. In the United States, all bar associations are legal persons, registered either as limited liability corporations, LLCs, but most of them are nonprofit organizations, NPOs. But as legal bodies, they can sue or be sued in court. So they are very careful to maintain the highest ethical standards in their policies and in their structures. Now, they all charge membership fees set by their own boards and executive bodies, and the executive bodies are elected by the lawyer members themselves. Most bar associations have membership policies on the fees that can be waived or reduced drastically if a member of the organization is serving full-time in the public interest, such as, for example, a state legal aid attorney that doesn't make a great income, or, in my case, an attorney for a nonprofit organization. So before I mentioned continuous legal education, I'll refer to this as CLE. So what is CLE and how does it work? Well, first, a little background. In the United States, attorneys are accredited to practice law by the respective states. I mentioned that I was accredited and certified by the state of New Jersey, but because my field was asylum and immigration law based on federal statutes, I could practice my brand of law anywhere in the United States. But for most areas of the law, you need to be specifically certified by that specific state, especially if you intend to litigate a civil matter in court or to represent a criminal defendant. But CLE is a requirement of all states. Continuous legal education is a requirement for every practicing attorney in the United States. Now, I was lucky to be certified in New Jersey because in 1995, they only had a one-time requirement immediately after you were sworn in to sit down for 2 weeks and take a course, one course for professional legal ethics. I satisfied my CLE requirement for my entire career based in those 2 weeks. Other states are much more demanding, and they require CLE certification every 1 or 2 years, depending on the state. If you don't do your CLE, you are not going to practice law. The state bar will terminate your bar membership. But the bar associations can be very helpful in this because CLE training is managed and administered either by accredited law schools or by bar associations at specific levels. A very positive aspect of continuous legal education is that you can choose from a wide range of specialized legal topics and deepen your chosen area of expertise. CLE trainers are not certified by the bar associations or the states, but identified as subject matter experts by the bar associations. Now, remember earlier, I said that the bar associations are legal persons. They can sue or be sued. For that reason alone, they are very selective of who they invite to serve as expert trainers for continuous legal education. How does continuous legal education benefit the community? Now, continuous legal education not only guarantees that lawyers advance their skills in the legal profession, but it's also an opportunity to help people, which I consider a best practice. As a continuous legal education instructor in international human rights law for the District of Columbia Bar, I trained many young attorneys each year. Now, these young attorneys were working for private law firms, some of the biggest ones in Washington, D.C., some of the richest, most powerful law firms. But as junior members, they were stuck in their offices for 60 hours a week, and they simply didn't get to practice the type of law that they were interested in. They were very much motivated to learn about international law and to use the skills that they had acquired in law school to try to help these people. But they couldn't do it. They couldn't afford to because when they left their law schools, they left with tens of thousands, hundreds of thousands of dollars of debt. So they needed to work for the large law firms. The law firms would send their young attorneys to the D.C. Bar's continuing legal education program, and they would be trained by me as an expert in international human rights law. Then, under the terms of the agreement, those same attorneys would come to work for us a certain number of weeks each year and still get paid by their firm to do that. They would develop skills, they would represent our clients, but they would be under our mentorships because we were ultimately responsible for our clients. And this is how we sold it to the law firms. Under the terms of the same agreement, those hours that were spent with our organization were by far exceeding the minimum amount of hours that were required under the state standards for pro bono service. So what do you do with these extra hours? The agreement allowed us to credit the firms themselves, meaning all the attorneys in that firm, for their pro bono requirement under the law, so that everybody could satisfy pro bono service through the service of those few young attorneys that were working with us. It was a brilliant system, and everybody wins. So the clients win because they got very high quality legal representation by skilled and trained and mentored private firm attorneys who were very, very good working in Washington, D.C. Those same young attorneys, they developed skills in international human rights law that they normally wouldn't acquire working for the big firm. And they also got the opportunity to work in an area of the law that they normally couldn't afford to do it. Of course, my organization was very happy because we got the free legal services of some of the best young attorneys in DC. And we were able to expand our services and help more clients. Lastly, the big firms were very happy about this, not just because that everybody was satisfying the pro bono requirement, but they were also feeling good about doing it. And it didn't help the publicity, the public relations for these big firms to let it be known that they were devoting a good, substantial portion of their young talent to promote the community good. Thank you for your attention, and good luck with the program.